Thank everybody. Hopefully you can hear me and see me. Excellent. All right, welcome everybody. I'm Darla Price. I apologize, I've written that in my notes to actually introduce myself. I'm Darla Price, Managing Director from the NMA. Really proud to have this event here today and having this wonderful partnership with Pinchin and Willms Shier Environmental Law to bring to you today an amazing educational session on what we believe, and I think everybody could agree, on what matters most to us, and that is our environment. So just a few housekeeping issues before we begin. The session will be recorded and attendees' microphones will be muted for the duration of the presentation. There will be some time for Q&A at the end of the session, but in the event we run out of time, all questions will be collected and consolidated into a fact sheet. So please feel free to post your questions in the question and answer box down at the bottom of your screen, not the chat box. A copy of this fact sheet, the presentation slides, and a link to this recording will be provided to all attendees in the upcoming days. To keep things interesting, we have a few audience poll questions which we will ask, which will help the speakers better understand your needs. So let's start. Our first speaker today is Rosanna DiLabio. Rosanna has over 25 years experience in an industrial setting with strong focus on environmental issues, is very knowledgeable about environmental law and compliance requirements, and has been involved in inspections and investigations in numerous jurisdictions throughout Canada. She is licensed with the Professional Engineers of Ontario, holds a Master's of Science in Environmental Engineering from the University of Guelph, and is a certified environmental auditor with the Canadian Environmental Certification Approval Board. Rosanna helps clients manage their environmental compliance requirements. She works with clients focusing on stormwater and wastewater, permitting and reporting, acoustics, odor, ventilation, and air and noise permit compliance. Our second speaker today is Julie Abouchar. Julie is a partner at Willms & Shier Environmental Lawyers, LLP, and is a certified specialist in environmental law and Indigenous legal issues, things like rights and governance, corporate and commercial, all law Society of Ontario. Julie has special expertise in water regulation, including discharges, drinking water, and source water protection. She advises clients dealing with the Ministry of Environment, Conservation and Parks and bylaw officer investigations, environmental charges, and director's orders. She advises companies and directors and officers about corporate and personal environmental liability. Julie is also a co-author of the Ontario Water Law, published by Canadian Law Book. Julie is peer selected annually for inclusion in the best lawyers in Canada for environmental law, Aboriginal law, and energy energy regulatory law. She is ranked repeatedly recommended by the Canadian Legal Lexpert Directory for Environmental Law and Aboriginal Law. And in addition to her law degree from McGill University, Julie has a Bachelor of Science in Earth Sciences from the University of Waterloo and a Master's in Environmental Law from the University of London, UK. Julie is called to the bar in Ontario, New Brunswick, Northwest Territories, and Nunavut. Those are some pretty fantastic women. Rosanna, whenever you're ready.
Thank you, Darla, for arranging this, and thank you to everyone for attending today. I'm going to talk a little bit about air permitting in Ontario and tell you what you need to know about water discharges. And my co-presenter, Julie, will provide you with some tips on how to report spills, how to deal with the regulators when they come visit your facility, And she will also speak about what to do if you receive notices of violation and orders, as well as what the potential charges may be. In Ontario, manufacturers that discharge air contaminants into the environment as a result of their operations must obtain a permit to do so from the Ontario Ministry of Environment, Conservation and Parks. And I'll refer to them as the MECP. So I just wanted to start with a poll question, and I wanted to understand from the audience whether or not you have an environmental compliance approval, whether it's for air or water discharges. And I'll give you a few seconds to answer. So it looks like it's about 50% of the attendees that have an environmental compliance approval. That's great. So you'll get some really good information out of the next few slides. So these are the regulations that apply to air emissions in Ontario. We have the Environmental Protection Act. We have Ontario Regulation 419 that was passed in 2005. And that's the air pollution, local air quality regulation. And then we have the most, I guess, recent Ontario Regulation 1 that was passed in 2017. And that's the activities requiring assessment of air emissions, or the famous new EASR. These regulations specify the conditions in which air discharges are allowed and what type of permit has to be obtained to discharge them. So these are typical industrial air emissions that are regulated under the regulations I just mentioned. Chemical processes, fume hoods, all of the emissions from those, combustion equipment, cooling tower exhaust, noise, dust, and odor. So very low risk sites would be exempt from any kind of provincial air permitting. An example of that would be, for instance, a commercial plaza with a Home Depot that might have a backup power generator, and the Home Depot itself might be cutting wood for customers, and they would have a dust collector for that wood cutting operation. So those would be the exempt type of sites. And then we have three categories. We've got the EASR, the simple sites with low risk operations and air emissions. We've got the assessed EASR, which are less complex sites with medium risk operations and air emissions. And those assessed EASRs would be applicable to the majority of the NMA membership. And then there'll be a select few that would require an environmental compliance approval. And this is the traditional approval process, very complex sites with high risk operations and high risk air emissions. So this would be like a, say for instance, a petrochemical facility. So for the assessed air and noise EASR, there's a requirement to prepare supporting documents for your application. These would be emission summary dispersion modeling report, which is essentially a blueprint for your air emissions, an acoustic assessment report, which is a blueprint for your noise emissions, and that may or may not be required, and I'll talk a little bit more about that in a moment. You would need operations, maintenance, and monitoring procedures, a procedure to address complaints, best management practices plans for dust if it's a source at the facility, odor screening form and an odor control report if the screening form indicates it's required, as well as the best management practices plan for odor, again, if the screening form requires. The benefit is, with this assessed EASR process, is that you will get immediate approval, and the application is not subject to technical review before the approval is issued, but you may be subject to audit afterwards. So for process and timing around the assessed air and noise EASR, you would verify your eligibility requirements to make sure that you can indeed apply for the EASR. The documents to support the application would be prepared by a licensed engineering professional. You would have to implement your operating maintenance and best management practices plans procedures. You would register the company online on the ministry portal for EASR. You would have to click a few boxes that I guess declares that your application is true and accurate. You would submit the registration and pay the fees, and voila, you'll have your approval. Afterwards, you have to maintain the required documentation. As I mentioned, you may be subject to audit afterwards. And you would be required to update the information provided if there were modifications made to your operations or 10 years after the EASR was granted. So as you can see, manufacturing sectors that qualify for this assessed EASR will benefit greatly by obtaining the approval upon submission of the registration and the payment of the fee, but not all industries are eligible to apply. And it is worth noting at this point that a facility's compliance obligations don't end when the EASR is obtained. In fact, they're just beginning. And should there be any changes at the plant, whether it's chemical or equipment, that would have to be evaluated prior to implementation. And under most conditions, only an update to the ministry website would be required. For the traditional environmental compliance approval, those sites that don't qualify for an assessed EASR must follow this process. So again, verify the site is not eligible for the air noise EASR. The same documentation needs to be prepared. It's submitted to the ministry with fee payment. And once the application is screened, it's posted on the environmental registry for public comment, and then subject to a 1-year review period by the ministry. Upon completion of the review, the ECA is issued and the registry posting is updated to indicate that. And then there's a requirement to implement terms and conditions of that particular approval. So similar to an assessed EASR, changes that occur in the plant processes must be evaluated, and if needed, an application may need to be refiled to account for these changes. These could be changes in chemicals used or equipment installed. So as I mentioned earlier, there is a requirement to assess for noise depending on how close your facility is located to what the ministry calls a sensitive receptor. This is a school, daycare, residence, place of worship, etc. If it's determined that the operation is located less than 1,000 meters from a sensitive receptor, an acoustic assessment must be completed and submitted with the approval application, whether it's an EASR or an ECA. If it's a chemical emission or a noise emission, the facility must always show compliance with the limits established by the ministry prior to submission of their application, or provide an abatement action plan with the submission to explain how the facility plans on achieving compliance. Odor and dust management plans may also be required for those industries where these aspects are expected. As mentioned earlier, your compliance obligations do not end once you receive your approval. In fact, they're just beginning. This slide illustrates how over time a facility can go from being in compliance with their noise limits to being out of compliance because a sensitive receptor has moved into the neighborhood. It is wise to know how the land use is changing in your neighborhood so that you can take action before the change to ensure you do not have to implement costly noise mitigation measures. So now I'll talk a little bit about water discharges and start with those discharges to the natural environment. Like air emissions, if your facility is discharged directly into the environment, your facility is required to obtain a sewage ECA. And the regulatory landscape around sewage ECAs is covered under the Environmental Protection Act of Ontario, the Ontario Water Resources Act, and the Fisheries Act. So unfortunately, there is no EASR currently for sewage discharges. So the air ECA process pretty much is very similar to the sewage ECA process. You would need to confirm the type of sewage ECA required, whether it's stormwater, industrial sewage, or private sewage works. You would prepare the supporting documentation, you would submit it and pay the fees. The application would be screened, the proposal posted on the environmental registry, and then subject to a 1-year technical review period at the ministry. Once approved, the ECA is issued, the registry posting is updated, and again, there's a requirement to implement the terms and conditions. Just as for air approvals, should there be any changes in the sewage works that could affect the quality or quantity of the discharge, an amendment to the approval is required. And this could be a change in equipment used to treat the sewage or how the sewage travels through the treatment process. For discharges to sewers, each town, city, or municipality will have its own sewer use bylaws. These entities are required to meet their provincial approvals for their discharges to the natural environment and therefore impose limits related to the capabilities of their treatment system. So although my presentation only addresses sanitary and combined sewer discharges, the audience should know that there are stringent limits to what can be discharged to storm sewers. Typical pollutants that would be found in industrial effluent include biological oxygen demand, total suspended solids, phenolic compounds, phosphorus, oil and grease, and nitrogen, or more commonly referred to as TKN or ammonia. Sewer use bylaws specifically prohibit certain characteristics of discharge streams, such as pH is limited between a low of 5.5 and a high of 11.5. Sewage discharges cannot contain 2 or more separate liquid layers, to have a temperature greater than 60 degrees, or any discharge that has been diluted with clean water to meet any of the requirements of the bylaw. There's also a list of substances that are prohibited from being discharged to a sanitary and combined sewers, and these are like metals like hexavalent chromium, chlorinated organics, solvents, pesticides, PCBs, etc. So this table shows typical industrial plant wastewater characteristics and the limits associated with sewer use bylaws. So we're looking for biological oxygen demand. Typically the limit would be in and around the 300 range. For TKN, about 100, oil and grease, 150, total phosphorus, 10, and total suspended solids, about 350. Stormwater limits are generally 10 to 1,000 times lower than what can be discharged in a sanitary or combined sewer, and many contaminants that are allowed in limited quantities in these sewers are also prohibited in storm sewers. So to find the sewer use bylaw that applies to your facility, you just need to Google the city name and the word sewer use bylaw, and that will bring up the information for the jurisdiction you are interested in. In order to determine if your facility complies with the sewer use bylaw, you have to assess for compliance. So you can conduct a sampling and analysis at the discharge point or the property line of your facility. It would be the point that is farthest from the process, but closest to the connection to city sewer. And if you've ever had the city come and sample at your site and you know the point at which they're sampling, that would be the point you would want to look at. You would have that sample analyzed, compare it to the results of the city bylaw limits, and report the exceedance to the city. After that, then you would begin investigating to determine the source. So although this applies to sanitary and combined sewer discharges, For storm sewers, if your discharge doesn't comply with the bylaw limits, you can bring the parameter levels down to below. You must do that. There's no other option to pay for overages in storm sewer discharges. And if you were to assess compliance for a discharge to the natural environment, you would sample at the point of discharge and compare the limit to the limits in your sewage ECA, and also report any exceedances to the regulator. To investigate or determine the source of an exceedance, you may have to look further back in your process to determine exactly where the substance, the offending substance is coming from. The next step then would be to enter into some sort of compliance program with the city while you're working to reduce the discharge limits, to meet the limits. Then some jurisdictions also require the submission of a pollution prevention plan, but some have it written into their bylaws, whereas others will request it. And then you would look at reducing or eliminating the discharge by source reduction or substitution in process recycling, using a third-party equipment supplier to help you pre-treat that waste before discharging it. And as a low priority, you would accumulate that material and then send it off-site for disposal. Once you've completed these steps, if there are still overages on your surchargeable parameters, and I mean BOD, TSS, TKN, phosphorus, then you would enter into a surcharge agreement with the particular city or municipality and pay fees for the overages. So before I pass the presentation over to Julie to discuss the legal aspects, I wanted to ask the audience one more poll question. Have you been visited by a regulator in the past 3 years? So I'll give a few seconds for everyone to post their answer. Wow, it looks like 40% of you have had a visit by a regulator, excuse me, in the last 3 years. That's too many. So now I'm going to pass it over to Julie to talk to you about the legal aspects.
Hello, everybody. Thank you to Darla and Rosanna for inviting me to speak with you today. You've heard from Rosanna about the process of getting approvals to allow discharge from facilities into air, water, and sewers, and how to determine compliance with approval and regulatory standards, and also how to achieve compliance. My section of today's talk is about what to do when trouble happens. For example, a discharge exceeds your approval or a regulatory standard, or an official shows up unannounced at reception. I'll be discussing key sections in the Environmental Protection Act and sewer bylaws, the obligation to report discharges and spills to the regulator, the difference between an inspection and an investigation, and your rights and obligations in each, how to respond to a notice of violation or an order under a bylaw, or an order from the Ministry of Environment, Conservation and Parks, and how to respond to a summons. So the purpose of talking with you about this is so that you can limit your risks to your facility, risks to the employers and directors, including substantial fines or even jail time. I will be sharing just a few slides today, and we will send our full slide deck to you after the sessions. The main prohibition in the Environmental Protection Act, and I'll be saying EPA from now on, is in section 14, It says, a person shall not discharge a contaminant or cause or permit the discharge of a contaminant into the natural environment if the discharge causes or may cause an adverse effect. Many of these words are defined in the EPA, and you need to be a bit of a language nerd and dig into the text of the legislation to know if you've breached this section. So for example, contaminant means any solid, liquid, gas, odor, air, sound, vibration, radiation, or combination of any of them resulting directly or indirectly from human activities that cause or may cause an adverse effect. So there's lots of language there that may come as a surprise. For example, sound is contaminant. The contaminant could be directly or also indirectly from your activity. And it doesn't have to have caused an adverse effect. It may potentially cause an adverse effect. And then the definition of adverse effect is very long. Some of it is intuitive, like environmental impairment. Other effects, like damage to property, personal discomfort, loss of use and enjoyment of property, or interference with the conduct of business, is not exactly what you'd expect. And then adverse effect is also interpreted by the courts. If there's any room for interpretation in a charge, you might end up before court arguing that you haven't in fact caused an adverse effect. However, the adverse effect has been interpreted by the courts very broadly, so that rocks flying into a house or a spilled potable drinking water have been considered to cause an adverse effect. And some might argue, and this gets a chuckle around our office, if a child hits a baseball into a neighbor's window, it could actually be considered a contaminant under the EPA. So also, you don't have to actually have been on the scene to have to be considered to have caused the discharge or spill or be responsible for it. You could have permitted it. Directors and officers, senior management of corporations could permit an offense even if not on the scene. So I'm now going to talk about the obligation to report. Who reports, when, how soon, and to whom do you report? Starting with who. Those with control, or those who cause or spill or cause a spill or a discharge, must report. But first you have to recognize a spill or a discharge. The obligations are somewhat different if it is spill or a discharge, so it's important to understand the difference. So here's a table comparing the definitions. We have the definition of a spill under the sewer bylaw, and that's on the left-hand side. It means a direct or indirect discharge into the wastewater works, stormwater, the natural environment, which is abnormal in quantity or quality in light of all the circumstance. Then we have the definition of spill under the Environmental Protection Act, which is slightly different. When used with reference to a pollutant, it means a discharge into the natural environment from or out of a structure, vehicle, or container, and that is abnormal in quality or quantity in light of all the circumstances of the discharge. And then the definition of discharge under the EPA means to add, deposit, emit, or leak, and when used as a noun includes addition, deposit, emission, or leak. So the key difference between the definition of a spill and a discharge is that under the Environmental Protection Act is that the spill is something that comes from or out of a container, structure, or vehicle. Although the definition of discharge under the EPA does not have the abnormal in quality or quantity language, the requirement to report is only triggered if it is abnormal in quality or quantity. The timing of the report should be immediately, although the EPA uses the lovely old-fashioned term forthwith. For either a spill or a discharge, it is understood that the reporter can first ensure personal safety, take steps to, initial steps to control the damage, and gather basic information. However, you should not wait until you have full information about the incident to report. A case in point on this is DeFasco, the DeFasco case of February 2005 concerning a spill into the Hamilton Harbor. In this case, the company spent 3.5 hours investigating and remediating before reporting. And the court found that this was not forthwith, it was too long. That is not to say that one should not investigate and remediate, just that this should not delay reporting for any significant length of time. And there's also an obligation under the EPA to remediate, that's section 93 sub 1, including to forthwith or immediately do everything practicable to prevent, eliminate, and ameliorate the adverse effect and to restore the environment. So getting back to reporting, to whom do you report? This is different depending if it is a spill or a discharge. For a discharge into the natural environment, you must report to the Ministry of Environment, Conservation and Parks through the 24-hour Spills Action Center number. For a spill into the natural environment, you must report to the Spills Action Center, but also the municipality, the owner of the pollutant, and the person with control. For a spill into a sewer, you must report to the municipality, the owner of the premises, and anyone directly affected, and call 911 if there is immediate danger to health and safety. But what if you have spilled somewhere that looks like this? And we have our next poll question. Is this a water course or a sewage works, or is it both? I'll just leave some time for you to answer the question. Okay, so 38% say water course and 62% of you say that it is both. Well, you're right. That 62% of you who said it was a water course was both are right. It is a water course, so you're right too, the rest of you. It is a water course. It is also a sewage, part of a sewage works. And so you've got to report, in this case, you've got to report to all of those on the list, everyone you would report to under the municipal bylaw as well as under the Environmental Protection Act. And of course, that list, I'm sure you weren't all taking it down precisely. It will be in the slides, so you'll have it in the deck. So after a spill, or at any random time, you may receive a visit from a regulator. Now, the outcome of the poll that Rosanna did was that 40% of you have been visited by a regulator. It would have either been an inspection or an investigation. And when this happens, you have a number of questions. Do you let them in? What questions do you ask them? How you respond depends on whether it is an inspection or an investigation. So let's start with inspections. The purpose of an inspection is to verify compliance with the Act. They may take place anywhere except a dwelling, that an inspector reasonably believes there are substances or documents related to the Act. In an inspection, you are required to let them conduct their work. Inspectors may ask you to provide reasonable assistance, including providing information needed for him or her to reasonably carry out the inspection. You should know it is an offense for you to provide false or misleading information or samples, or to prevent or hinder an inspection from doing his or her work. Inspectors have the authority to take samples, conduct tests, take photos, video, or tape recordings, remove documents to copy and return, require repair, maintenance, disconnection of a sewage works, require relevant documents, require a person to carry out sampling. They don't need a search warrant from a court to conduct an inspection. An investigation is more serious. The purpose of an investigation is not to confirm compliance, but to find evidence of an offense. An investigation occurs where there is reasonable and probable grounds that an offense was committed. And a visit may start as an inspection, but become an investigation if the inspector finds reasonable and probable grounds during the inspection. An investigation can involve police assistance. Unless the circumstances are urgent, for example, imminent loss or destruction of evidence, or the officer has a search warrant, you don't have to let the official in for an investigation. So what to do if an officer shows up unannounced with a search warrant? First, ask to see a copy, review it with legal counsel to determine the scope of the investigation and if the warrant was properly obtained. Then cooperate with caution. As a search warrant is a court order, non-cooperation is contempt of court, and there could be criminal sanctions. But there are steps that you can take while still being cooperative. Ask for a list of items seized. Segregate and seal any documents over which you can claim solicitor-client privilege. It is best practice to keep those documents in a separate file or separate location on your computer drive. This would include any consultant reports prepared for your lawyers to use to advise you. You may have more flexibility if it is an investigation without a warrant. First, as there is no warrant, ask them if they intend to carry out an inspection or an investigation. If it is an inspection, ask periodically throughout as things may change. If it is an investigation, you may be able to negotiate a time of the investigation, a time when your lawyer could be present. Corporate counsel may also be present for any interviews with personnel. You may substitute a person for the one being interviewed. You may ask to receive the questions in advance. We are frequently asked for tips for dealing with investigators. There are some basic behaviors of investigators to understand. They may come across as smooth and friendly. Nonetheless, remember that they are not your friend. In this case, resist the urge to be overly helpful. On the other hand, they may be more assertive, and in this case, you may feel intimidated. You should know that there are basic things you can and should do to protect yourself. For example, you may accompany the official during the visit, take split samples, make notes of the investigator's questions, and record the investigation. You should only answer questions that you are sure of, and don't rush to fill in gaps or be overly helpful. You need only give materials that are relevant to the scope of the investigation. The investigator will prepare a written statement of what was told him, and you will be asked to sign it. If signed, this may become the central evidence in the hearing without the Crown having to prove it. So you don't have to sign such a statement. As with inspections, it is an offense to hinder them, provide false or misleading information, or refuse to provide information that you're required to maintain. It is not an offense to assert charter rights, refuse to furnish solicitor-client information, or not to let an investigator in without a warrant. After an inspection or investigation, you may receive a report listing non-compliances from the ministry or a notice of violation under a sewer bylaw. The notice of violation looks like this. This notice of violation is from the City of Toronto Water Department. It would look similar for different municipalities. It indicates in the line that it is a violation, and it says that notice is hereby given that on certain days, a discharge of matter into the sewer from the premises at the location identified was sampled and analyzed, and the results are reported in the table below. And it indicates what provision of the municipal code or the municipal code you're alleged to have breached. Then it will show you the results of the analysis, and it will provide fine information under the bylaw. And then in the last paragraph here, there is a requirement to investigate and advise Toronto Water of your proposed actions to come into compliance within 30 days. So while this is an example from the City of Toronto, municipalities will have something similar as a notice of violation. In all cases, it'll identify the non-compliance and what you need to do to come into compliance, and will give you a certain amount of time to comply. Do not ignore this. If the company does not take those steps and report within the time period required, charges may be laid, and you may be issued, next you may be issued an order, either a provincial order or a municipal abatement order, and that requires you to do certain things to remedy your non-compliance. Now, if you don't comply with an order, or in the case of provincial orders, if you don't appeal it within 7 days, that you could be charged for non-compliance with the order, and the municipality or the ministry may step in, take the steps required in the order, and try to recover costs from you and charge you. So you'll be informed of a charge with something called a summons, and that looks like this. This tells you the specific provision of the act that you are charged under, and the specific date and time of the alleged offense, and it sets a court date for a first appearance. If a company representative or legal counsel does not show up, the trial may continue on and charges may be laid. Resolving charges does not happen at one court appearance. There may be several judicial pretrials in front of a justice of the peace to attempt to settle. To prepare, the company will want to engage legal counsel who will interview personnel and determine how strong a case the company has. If not in compliance, the company will want to take steps to come into compliance even while the charges are not resolved. This could help to support arguments for a lower fine. By comparing the language with the facts of the charge, your counsel will assess whether the Crown can make out its case. So for example, when we looked at the section 14 at the beginning, and all the specific adjectives of the offense, that's what your legal counsel will be looking at, comparing to the facts of the case, and will determine if charges can be made out. And if all those elements of the offense cannot be made out, your counsel will argue that the charge should be withdrawn because there's no reasonable grounds for prosecution. There's no reasonable prospect for success. For example, in one case that Rosanna and I worked on together, the city had not sampled according to standard practice. And using a report, a technical report, we were able to convince the Crown during a judicial pretrial to withdraw the charge. Alternatively, counsel may determine that yes, all the elements of the offense can be met, that unfortunately the company did their actions were contrary to the legislation, but based on an interview and all the evidence, they may be able to show that your company took all reasonable care to prevent the offense and show that prove a due diligence defense to the charges. If the charges are not settled in this back and forth and judicial pretrials within a reasonable time, the charges will then go to trial. And here is the fine range for infractions under the sewer bylaw and under the Environmental Protection Act and the Ontario Water Resources, the provincial legislation. So there are just a few things to point out. First of all, fines under sewer bylaws, you can see, are significantly lower than the potential fines under the provincial legislation. Second, focusing for a minute on the, for subsequent offenses, the fines are higher. So if you've already had one offense, and then you're charged again, you're automatically looking at double what you were charged the first time. If you can't, you know, if the elements of the offense can be proven, you're automatically looking at a higher fine if it's a second offense. Another thing to notice from this chart is that there's liability for both corporations and individuals. So individuals who caused or permitted or who had control of the enterprise could also be subject to fines. And for Environmental Protection Act offenses, there's a potential for imprisonment. And now this, I don't want to scare anybody. The situations that we're aware of imprisonment are where an individual sort of was blatantly ignoring what the ministry was asking of them, and you know, did things that they knew that they were not to do and were hiding it. So it's really quite rare for imprisonment, but still you should know that it is a potential. And the final item on this slide is that there is a mandatory 25% added to the fine for fines over $1,000, and that is called a victim fine surcharge. Okay, so this is just some takeaways to wrap up. We would like to leave with a few thoughts. First of all, compliance with terms of approval should be your standard operating procedure. Being in compliance can prevent environmental liability. If you do receive a notice of violation, take steps to come into compliance. And if you receive an order, you have two choices. Either you comply with the order or you appeal it. If you can't comply with an order, you need to appeal it, because failing to comply or appeal will may result in the work being done by the regulator and in charges and penalties. Our second takeaway, not just corporations, but individuals who caused or permitted or who had control can be charged. Third, to reduce liability, know your rights and obligations. For example, recognize a spill or a discharge and know when to report a spill or a discharge. Know how to conduct yourself in an inspection or investigation, and know how to respond to a notice of violation by taking steps to comply. So thank you for joining us today. I'm going to pass the mic over now to Darla to field questions and answers.
Excellent. Thanks, Julie and Rosanna. I've actually got two. My first question, I have a feeling it's more Rosanna based. If I had a choice, or if I had the choice, would it be better to discharge to city sewer or direct to the natural environment?
I think it would be better to go to city sewer. The discharge limits are much higher than what they would be if you were discharging direct to the environment. And you could, I guess, avoid having to treat the water prior to discharge. You were sort of, you know, below or just hovering around the city bylaw limits. And there's also some room, like I mentioned in my presentation, for you to be able to negotiate an agreement with the city where you would pay for your overages if you were slightly over on your discharges. Julie, did you have any
Sure.
Sure.
Sure. From a legal perspective, you know, that I would agree with Rosanna, because, I mean, first of all, fines to the sewer, if you did discharge over your limits and you couldn't get under, the fines are much lower than fines for infractions under the EPA and OWRA, as you saw from that last slide. So the liability is greater if you're discharging to the natural environment and you know, and something happens.
Okay, great. I just wanted to remind guests, if you have a question, along the bottom of your screen, there's a little icon called Q&A. You can click on that and post your question. My second question is probably more for Julie. If an officer starts with an inspection that turns into an investigation, are they obligated to tell me?
So they should tell you, but they are not obligated. And so that's why we encourage you to ask during the inspection and in case things change. I mean, the other confusing thing is that sometimes it's the same people who show up to do the inspection as to do the investigation. So don't assume if it's somebody who last came for inspection is here this time for an inspection as well. So they should tell you, but they're not obligated to. So it's a good thing to keep asking during the course of the visit.
Okay, great. And I don't see any other questions. Oh, I have one here. If an on-site sewage system, which is under 10,000 liters a day, breaks out onto the ground, what steps need to be taken?
Well, it's my experience that if you have a breakout, that even though that's not, that type of system, because it's under 10,000 liters a day, is required to have sewage ECA, I would still consider that a spill. And Julie, based on your definition, out of the normal course of events, to me that would prompt me to want to report that to the ministry.
Yes, so it is a spill. It is out of a container, the pipe, and it is out of the normal course of events. It would be considered a spill and reportable, and also Section 93 would kick in and require immediate or forthwith remedy of the cleaning up.
Okay, great. Thank you. Just give another second or so to see if there's any questions coming in. Takes a couple moments to type. And just so you are aware, the question, oh, I'm not sure if they're anonymous. I can see who it is, but I'm not sure if everybody else can. In case I think you can answer or ask a question anonymously, in case there's information that you want to share, but you don't want to know, you don't want us to know who it is, you are more than welcome to do that as well. No, I think we're good. That's excellent. Question time 107. Excellent. If there's any other questions, I think we're okay. So we'll wrap it up. I would definitely like to say a huge thank you to Rosanna and Julie for taking the time and putting the presentation together and sharing your expertise. It's one of the things we're very proud of at the NMA, is our ability to share the good and the bad, and be able to pull in associate members like yourself to be able to share that expertise that will continue to allow us to be successful and to manage our environmental. So I really appreciate Julie and Rosanna for your time. For everybody else who's here with us today, I think it was some great information that came out. Please look forward to follow up, the deck slide, the presentation, and a link to the recording in case you want to share it with other staff members in your group. Please do. On behalf of Pinchin, Willms, and Shier and the NMA, I hope you enjoyed our workshop on air and water compliance, and we thank you so much for attending. Have a wonderful day.
Thank you.
Thank you,
everyone.